attorney for Crittenden County. Here today is Robin Wadley, who is here and has stated that he represents Angela Grinnell, Terry Grinnell, and Matthew Baldwin. Is that correct?
That's correct.
And you represent them as their attorney?
That's correct.
And you have stated that Angela Grinnell, Terry Grinnell, and Matthew Baldwin are here pursuant to prosecutor subpoena, but are declining to testify before the deputy prosecutor.
That's correct, and I want to set forth my reasons. Firstly, that they were served, it's my understanding they were served yesterday afternoon at around 4 p.m., somewhere in there, that pursuant to Art Code in 1643-212, we recognize that the prosecutor has a right to conduct prosecuting subpoenas. Which, as set forth in Cook v. State, 623 Southwest 2nd 820, 1981, which sets forth that the subpoena power of the prosecutor, the purpose is to enable prosecutors to properly prepare criminal cases. Art Code Ann 1643-211 provides that the provisions of the Code of Practice in Civil Cases shall apply. It's our position that means the Arkansas Rules of Civil Procedure, which require under Rule 45 proper notice under subpoena. We did not have proper notice for the subpoena in order to, and the rationale behind the rule is and it's set forth in the rule to allow the proper filing of a motion to quash a subpoena, which we have not had an opportunity to do. We are not, thirdly, we're objecting, which would be set forth in a proper motion to quash, given proper time to file it, which we have not had, that requiring the subpoena and the purpose of the prosecutor's subpoena in this case is to require the giving of information which is not discoverable under by the state under Rule 18 of the Arkansas Rules of Criminal Procedure. We are not taking the position that the parties that have been subpoenaed here by Mr. Fogelman are not subject in the proper situation to being required to answer questions. However, it is our position that we have not had proper notice to do that and are agreeable to meeting with the prosecutor upon proper reasons and grounds to submit to the prosecutor's rightful subpoena powers.
All right, so that the record will be clear, do you want me to, just so we'll be clear, do you want me to serve them with another subpoena, or do you want me to reschedule?
I would agree. That would be agreeable to me to reschedule and give us a proper opportunity to file any motions to quash. I would not require you to resubpoena them.
What time next week?
Can I call my office?
You don't have a calendar?
I'm not. Hey, John.
We're going off the record for Mr. Wadley to consult with his office. We've agreed that the time will be 10 o'clock Friday. 1:30 Friday, September the 10th. Mr. Wadley will make his clients, Angela Grinnell, Terry Grinnell, and Matthew Baldwin, available.
The grounds I've set forth this morning are not exhaustive. and I will be filing a motion, possibly maybe filing a motion to quash the prosecutor's subpoena in this case, and at this time, subject to a ruling by a court that we do not have to be present, or subject to a ruling of the court, I will have those folks here present Friday at 1:30 in the prosecutor's office.
All right. Now, it is my understanding on the motion to quash that since we're continuing this matter until September the 10th, that motion to quash would deal with any matters other than the timeliness of the serving of the subpoena.
That is absolutely correct. That is absolutely correct.
This is John Fogelman. We're back on record. It is 10:10 a.m., September 2nd, 1993. The time scheduled for Joe Hutchison, Pam Hutchison, and Michelle Eccles to give their testimony before me as Deputy Prosecuting Attorney for Crittenden County, Arkansas. Val Price and Scott Davidson have appeared with their private investigator. They have informed me that they represent Joe Hutchison, Pam Hutchison, and Michelle Eccles in this matter, and have, and you can correct me if I misstate this, and have instructed their clients at this time not to submit themselves to the prosecutor's subpoena. We're going off record for a minute. We're back on record. The lawyers for Joe Hutchison, Pam Hutchison, and Michelle Eccles have also stated that without their waiving their right to file a motion to quash the subpoena, they are willing to reschedule this matter from today, which is the date shown on the subpoena, to Friday, September the 10th, 1993 at 9 a.m. And the only matter which the motion to quash would not deal with, and if y'all disagree with this, say so, would be the timeliness of the amount of time given to appear. Since we're rescheduling it.
That wouldn't be a problem. That's correct, and everything else stated by John is correct.
Anything else that y'all would like on this record?
I think we nothing further. Put the rest in our motion.
This is John Fogelman, Deputy Prosecuting Attorney. It's now 11:25 a.m., September 2nd, 1993. Present is myself, Inspector Gitchell, Diane Tier, and lawyers representing Damien Eccles and Damien Eccles Investigator. Do y'all say that y'all represent Miss Tier?
Yes, we do.
When were you retained?
We don't have to answer that. We are currently representing Miss Tier at this time. Any further questions about the scope of our employment, the scope of our representation is a confidential matter.
Miss Tier, would you raise your right hand? Do you solemnly swear or affirm that the statement you're about to give is the truth and nothing but the truth, so help you God?
I do.
Ms. Tier, as your lawyers, we're requesting that you not answer any questions at this time.
Is Mr. Price your lawyer?
Yes.
When did you hire him?
You do not, just a moment, you do not have to answer that question.
I never have to answer that.
Did he solicit your business?
No.
As I stated earlier, just one moment, she does not have to answer any questions. The scope of our representation is none of the business of the state, but she is not required to answer any of your questions concerning that.
It is the business of the state if lawyers and the investigator for the defendant Damien Eccles are interfering with an investigation. And if they went out and solicited Miss Tier and volunteered their services to represent her and her daughter, then that is the business of the state.
As we previously stated, it's our position that it's not in the state's business, and we're requesting Ms. Tier not answer any further questions about the scope of our representation.
Are you also instructing her not to answer any other questions for which she's been subpoenaed here to give testimony?
Yes, we are, because we currently represent her.
And that's the reason authorizing her not to answer any questions because you represent her.
That's correct. And for the reasons that she has not been subpoenaed properly, the same reasons we gave earlier.
All right. And as her attorneys, are you also agreeing, as in the prior people, that she will be produced at 9 a.m. on September the 10th, subject to any motion to quash for any grounds, save and except for grounds of the timeliness of the service of the subpoena?
Correct. Correct. Do you want it at 9, or would you rather have it at a different time?
She can come at 9 too.
Okay.
And are you also saying that you represent? Did you hire them? Let me ask you them this, and then you can instruct her or not. Did you hire them to represent both you and your daughter?
Yes.
All right. And does the same apply to the daughter Dominique here?
At this point, yes. That's correct.
All right. That ends this session.